attorney broker John McConnon, and I am going to compare a California residential purchase agreement with a form I found on the net. Now, I've reviewed 1-pagers and 3-pagers. I've reviewed for high net worth individuals, and I've drafted some of those, and that's a totally different game. That's between two sophisticated individuals, usually big money, not necessarily the home that they're planning to live in. So 1 and 3-page agreements, usually they've worked it out themselves ahead of time, then they put it into writing. And that's a separate ball game and an interesting one, but totally separate. Now, this is California Association Realtors RPA versus, say, some of the forms people selling their home or doing business without realtors or lawyers might do on their own. And I'm not even judging. I'm reviewing as opposed to judging. California, let's go over some of the outs in this form. First of all, there is the financing, or the major ones, the financing contingency. Within 21 days after acceptance, buyer shall, as specified in paragraph 14 in writing, remove the loan contingency or cancel this agreement if there is an appraisal contingency. Removal of the loan contingency shall not be deemed removal of the appraisal contingency. So there's appraisal and loan contingencies. There are, well, here's an important one to understand. In chapter 11 here, paragraph 11, we've got the property is sold as is. Now, not a lot of realtors discuss that or seem to know it. The property owners are being sold as is. They don't have to have, like, I can't tell you how many times I've been in negotiations for sellers and the buyer's agents act like, well, we had an inspector there and the windows aren't in great shape, or, the ceiling, they need to be resealed or recaulked. And the point is that the homes are being sold as is. No one says a 10 or 15-year-old house has perfect windows. Now, again, because of the way this is set up, the buyer can do the inspection. If the buyer's not satisfied with the inspection, the buyer, they really do have two options. One, they could cancel, or two, they could say, we would like you to fix these things. But it's more of like, we would like you to fix, as opposed to, hey, it's supposed to be fixed. So I think that buyer's agents need to be not nicer, but they need to approach it. If they really want to get a deal done, the buyer should know it's a request, and it's something that has to be agreed to. It's a negotiated thing. It's not a demand. I've seen sellers get pretty upset at the demands, and I don't really think the buyer's agents are trying to cause sellers to take umbrage and then ask their realtor or me, how do I get out of this deal? I mean, that's not really what's supposed to be happening. They're supposed to be, in the beginning, say, hey, we found these conditions. We really love the home, but we'd like these things fixed up. Do you think we can work on that? So anyway, and then here's the deal. So we have these inspections, and then let me see if I can find 17 days. Yeah. Well, the seller is supposed to give over disclosures. That'll be for another video. But then buyer 17 days after acceptance, unless otherwise agreed in writing, to complete the investigations and approve all matters affecting the property, and deliver seller signed copies of statutory and lead disclosures. Here's really the important one. Within the time specified in paragraph 14b1, buyer may request that seller make repairs or take any other action regarding the property. Seller has no obligation to agree or to respond to the form. Right, I've had people demand we respond using a form as opposed to an email saying, hey, we're going to do this, we're not going to do that. But I understand that because sometimes their brokers want the forms. But nevertheless, that's this agreement. Now, and it obviously protects buyers, and it protects sellers in, I'd say, balanced markets or buyer's markets. Sellers might not necessarily need to do this in a seller's market. Now, here is a form I found on the net. It's draft because I didn't pay for it. You get the draft removed by paying for it, but I had no intention of buying it. I'm just using it for education purposes. So here's their clause for an inspection. We saw how, I wouldn't say it's convoluted, but how complex the interaction between inspections as is and inspection removal was. Here we have, prior to the closing date, seller agrees to correct at seller's expense any violations found in connection with the inspection done to comply with the point of sale or similar ordinance required by the local governmental authority, if any. Evidence in writing that the corrections were made to the satisfaction of the local governing authority shall be given to the buyer prior to the closing date. I suppose this is saying in California we have to have the water heaters strapped so that they don't fall over during an earthquake. We have to comply with other safety concerns such as smoke detectors. Those things need to be done. Lenders won't lend unless those things are done. So that's why they frequently get done. But I think that's what it's getting to. But interestingly, there's no provision for an inspection or the timelines or what happens. There's no provision for the buyer saying, hey, I like it or I don't like it. I don't really like it. Would you fix it? There's no provisions in this agreement. This is sort of like you're putting the deposit down and you're closing. Sort of awesome for the seller. I not as good for the buyer. I'm sure you would agree. And so now, why did I do this? I just wanted to compare and contrast that situation. Now, this is why, actually. I get calls when buyers and sellers are in the middle of a transaction already, and they want me as an attorney to work it out for them, thinking that the attorney will still save them money over real estate fees. But at this point, if they want me to work with both of them and I see this agreement, I frequently told sellers I can't work with the buyer and you at this point in time because I'll probably blow your deal up. And so they think I'm putting them off or that I don't need money or I'm busy right then and there. And yeah, it's nice to be busy, but you still want to be more busy. So that's not why I'm doing it. It's that I read these forms, and in fact, they've taken the time to email me the form. I read it, and then I tell them that, and you can tell they're just sometimes not happy, thinking I was just pulling their chain. No, it's much better if you're going to work with me that we go over this ahead of time. I have no problem using a 1-pager or a 3-pager, even this form, but let's make sure we know what the disclosures are going to be. You give them ahead of time so this doesn't come up. I mean, there's a lot of things you can do to set up your transaction so you're working with a 1-pager. And in that case, too, let me just work with you. I don't really want to work with both sides. If you're going to do a deal with a simple contract, if you want to do a deal with both contracts and you want me to work with the buyer, I think that we're going to have to use something more, something similar to a California RPA, if not the California RPA itself, because otherwise I'm not going to feel that comfortable working on the buyer side, because this agreement is not anything like that agreement. The 1-pagers, the 3-pagers, the ones with very few outs for buyers is a significantly different deal. Now, it's fine in a seller's market, but I'm just saying that I don't think I want to work for both sides after this thing's already been done, because it's gonna. I don't even know how I can advise a buyer on that in this situation after the fact. John McConnon, attorney broker. You can usually find the stuff at either favoriterealestate.com. I may eventually put it up on my law site, but at the moment it's just going over to favoriterealestate.com. Thank you.